I'm Lisa Rubin, MSNBC legal correspondent. And on this edition of Can They Do That, I'll be looking back at the first 100 days of the Trump administration to see where the law has held up and where it hasn't. And my guest today is Cecilia Wong, National Legal Director of the ACLU. Cecilia, you oversee more than 200 lawyers and support staff in the ACLU's National Legal Department, and you also spearhead your organization's collaboration with the 54 affiliates that you have throughout the states, where there are hundreds more lawyers and staff. And you also, importantly for today's conversation, lead the ACLU's work in the Supreme Court of the United States. You've also worked for the ACLU for more than 2 decades. Thank you for coming to Can They Do That?
Thank you, Lisa. It's a pleasure to be here.
Welcome to the show.
Thank you.
Okay, so I said to you at the outset that before we get into some of the real nitty-gritty, I always like at the top to pose some of the more provocative, open-ended questions to my guest. So it's hard to overstate, given where we are right now, the ACLU's involvement in the court battles that have taken place to date against the administration. Given how deep the ACLU's involvement is in litigation across so many different issue areas, from immigration to medical research even, what's the most surprising thing to you from where you sit about this administration's policies to date?
So I think we went into President Trump's second term expecting him to go after birthright citizenship under the 14th Amendment, to more broadly go after the Reconstruction Constitution and the Second Reconstruction, all of the civil rights laws that protect all of us and our individual freedoms after the civil rights movement. I think what's more surprising to me is the speed and the breadth of Trump's all-out attacks on the underpinnings of a free country, all of our democratic institutions, attacking law firms and lawyers, attacking universities, attacking media companies and journalists, and really fundamentally destabilizing all of those preconditions for living in a free country in America. I think that the speed with which he has attacked all of those institutions has been surprising to me. We expected him to go after the people that he disfavors: immigrants, transgender youth, people of color, all the attacks on civil rights laws and fundamental freedoms and individual rights were expected. It's the attacks on the institutions that I think have been surprising in their speed.
The conversation I had with Jamal Green, a Columbia Law professor that you know as well, was about the attacks on civil institutions that sort of make up the fabric of civil society outside of government itself. So I find it interesting to hear you say that. So now here comes the tougher question. Again, from where you sit as the National Legal Director of the ACLU, what's the most pernicious thing that this administration has done from a legal perspective since January 20th?
It's really hard to choose because his attacks on individual rights have been so broad. There are so many Americans who've been harmed by President Trump's policies. I think to pick out 2 things that stand out to me.
I like rule breakers, so go for it.
Sure. So you said 1, I'll give you 2. One's free on me. I think what's happening right now with his invocation of the Alien Enemies Act, both in the case that we brought at the ACLU, now 7 separate cases, and in the case of Mr. Abrego Garcia, you see the president basically thumbing his nose at the courts. He still hasn't gotten to the point where he's openly defying the court. He's still making excuses. He's still changing a story, kind of bobbing and weaving to avoid a direct showdown. But we have a situation where the president of the United States,
it's really a semantic showdown too, right? When we think about a lot of the battles that we're having now about compliance are about semantics. They're about how do you interpret the meaning of a particular word, like the meaning of the word facilitate, for example. It sort of calls me back, and this is showing my age, to the Clinton impeachment era, where we talk about it depends on what the definition of the word is. That's where we are again, but I would argue with much more destabilizing effects for our democracy and the rule of law.
That's right. And I think we could sit here and talk for hours about the Abrego Garcia case and about our litigation in JGG and the follow-on habeas petitions. But what I would say about it, what's especially pernicious is that the president knows that under past precedents of the Supreme Court and under the unwritten norms that govern the behavior of presidents, if he says the magic words national security, if he says the magic words terrorism, that gives him leeway. And I think what you see in the Alien Enemies Act litigation that's ongoing around the country is that our legal system is going to have to come to grips with the fact that those unwritten legal norms, the expectations that the president of the United States is going to comport with the law, with fundamental human rights, with common sense, those expectations do not hold with President Donald Trump, particularly in his second term. And so I think what he's doing by sending people deliberately to a legal black hole, what he's trying to make into a legal black hole, and then basically telling the courts something everyone knows is false, that he has no control over whether he can return people back to the United States after he's arrested them and transported them to this gulag
And
unlawfully.
allegedly contracted with the government of El Salvador, paying them $6 million for the imprisonment of these folks who have been forcibly removed from this country.
And almost literally giving each other a wink and a nod in
Right.
front of the TV cameras. So that's the first thing I would
Okay.
say is particularly pernicious. The second thing I would say is pernicious is his attacks on law firms.
Okay.
So issuing executive orders on these major law firms, I think this is one of the surprises that I mentioned in response to your first question. He, I don't think many people had it on their bingo card that the president would be attacking Covington and Burling, Jenner and Block, Wilmer Cutler, and it's Wilmer Hale. He knows. Right, we filed an amicus brief on behalf of a right-left coalition of civil liberties organizations. Trump knows that the whole system that holds up the rule of law in our country depends on the court system, and it depends on lawyers to bring the issues in front of the courts. And I think that's why he has just systematically gone after not only individual judges and the court system, for example, calling for the impeachment of a federal district judge.
You're talking about James Boasberg and the District of D.C.?
That's right. And in relation to his rulings in our case, JGG versus Trump. But he's systematically going after these major corporate law firms because they have represented people that Trump views as his political opponents, or they have done pro bono work to support and defend civil rights in the United States and constitutional principles in the United States.
I'm glad you said that because we were sort of alluding to this before. I'm an alumna rather, of two such firms, one of which is a firm that has negotiated a settlement with the administration. The other has so far been outside the crosshairs. But among the things that I did as a practicing lawyer, which I am no longer, some of the things I'm most proud of are pro bono representations that we undertook in partnership with organizations like yours, like the Center for Reproductive Rights, or with an educational organization that was trying to ensure that New York City school children had a fair shake given provisions in the New York State Constitution. I don't know that everybody watching this appreciates that organizations like yours are not always the antithesis of organizations and institutions like the one I spent all of my practicing legal career in, but rather that they work hand in glove to uphold the rule of law. And in many cases, if neither your organization nor those law firms existed, clients would be in search of lawyers, right? The whole point is to deprive people of their counsel of choice in many respects by making it punitive for the law firms to associate with certain clients.
That's right. And it's not just about depriving individual Americans of their counsel of choice. It's about disrupting the whole system of justice, because the president knows that if he knocks out the lawyers, if he intimidates judges, how are we going to bring the cases? And that's why in our amicus brief that we filed in the Perkins Coie, Wilmer Hale, and Jenner and Block cases, we point out that his attacks on the law firms not only violate the First Amendment and people's due process rights under the Fifth Amendment and the Sixth Amendment, they also fundamentally violate the separation of powers. He's trying to make it so that all the institutions that might hold him in check as the founders of our country intended, he's trying to disrupt that. He's trying to knock the legs off the table that holds our free country up.
When we were speaking earlier, you mentioned that presidents for many years have used the words national security as sort of a magic incantation to excuse behavior or to justify behavior that might otherwise not be allowed. I'm glad you said that because it triggered for me a conversation I want to have with you about the use of Guantanamo Bay. From what I have read in mainstream publications, including the New York Times, the administration came in and seemed to have a plan to use Guantanamo as a holding ground, if not a more permanent solution, with respect to undocumented immigrants that it saw as deportable as part of a program of mass deportation. And for at least one point in time in late February to early March, they had as many as 400 undocumented immigrants living at Guantanamo. They repatriated almost 200 of them to Venezuela, flying them first through Honduras. They took many others and put them in ICE holding facilities in the continental United States until only a handful of them remained. And they have done that to great expense. It struck me in reading that they had some grand plan about the use of Guantanamo that they no longer seem interested in pursuing. And since the ACLU has been involved in some litigation about the use of Guantanamo with respect to some of these migrants, I wonder if you could tell me, what do you think they were trying to do? And am I right in deducing that that is no longer part of the grand plan?
So I think the use of Guantanamo by the Trump administration is similar to the way that the George H.W. Bush administration used Guantanamo, similar to the way that it's been used after 9/11, for example. But even earlier than that, you've talked about your law school experience. When I was in law school at Yale in the early 90s, George H.W. Bush was using Guantanamo to detain Haitian refugees who were interdicted on the high seas on their way to try to reach Miami, to reach freedom. And we litigated against that, both the ACLU and the Yale Law School Clinic. Then, of course,
this is the infamous Harold Coe Haitian boat refugee litigation?
Exactly.
Okay.
I was a little first-year law student in Team Haiti at Yale Law School in the early 90s. After 9/11, of course, the U.S. Started to detain law of war detainees there and still is. And so I think when President Trump came into office, we knew, because we had filed requests to the federal government under the Freedom of Information Act, we wanted to find out what the government might be preparing to do with immigration detainees on Guantanamo. And sure enough, as you said, when President Trump took office, he started to transport people who were in ICE custody and immigration custody within the United States to Guantanamo. We immediately filed a series of lawsuits. Number one, because when the president did that and transported people from the United States to Guantanamo, he deliberately was keeping them incommunicado. People suddenly found themselves with no way to contact their family, no way to contact their immigration lawyers if they had them.
And were they findable on the other end? So, for example, today, if I have a family member in ICE custody, presumably at least, and there are obviously lags in the system that you, the ACLU, have documented through attorney declarations and some of the litigation that you are proceeding with right now, what if I am on the outside looking for my disappeared loved one and I want to find Cecilia Wong at Guantanamo? I know in the usual way things are supposed to happen, ICE has what's called a detainee locator. It is literally a website where I can type your name and find out where you are being held. We know from some of the cases that the ACLU has been litigating lately, that there is obviously a time lag and sometimes what seems to be a purposeful time lag. But putting that aside for a second, if you, Cecilia Wong, are at Guantanamo, I am your spouse, your child, could I find you?
No, and that's the point. That
Right.
was their point. They were basically trying to take human beings who were in the government's custody in the United States and disappear them. That's the point of Guantanamo. That's the point of this gulag in El Salvador, the CCOT prison in El Salvador. The whole point of the Trump administration is to take people who, remember, the vast majority of people that we represent in the cases challenging both the transfer to Guantanamo and their disappearance to this torture prison in El Salvador, the vast majority of those people had asylum hearings coming up, right? Many of them actually seem to have been transported to be disappeared on the eve of an important hearing in their immigration cases as they were trying to win the right to asylum in the United States.
Can I pause you there? Because I think that's something that's kind of lost in this conversation is the role of asylum. So many of the people that the ACLU represents are undocumented in the sense that they have come to the United States in some manner that maybe was lawful initially, became unlawful at some point in time in that they overstayed a tourist visa or a student visa, or they may have crossed at a point of entry unlawfully. But as you noted, many of them have then claimed a right to be here under U.S. statutes by claiming political asylum. My understanding is that the basis of that claim, the genesis of that claim is if I stay in my country of origin, I will become a victim of political persecution, in many cases motivated by some of what we would consider immutable characteristics, sexuality, gender, country ethnicity. So, for example, some of the people who have come here and claimed asylum are what I understand are ethnic minorities in their country of origin where there is significant strife. And what you're saying is people come here and maybe they don't have documentation, but they are in the process of trying to get permission within the legal structures of the U.S. to stay here, subject to immigration laws that allow for claims of asylum. They get a hearing, they are awaiting that hearing, and then the government takes them, puts them in ICE custody, maybe here in the continental U.S. or not, or they send them to Guantanamo. Do I have that all right?
You have that right. Many of these individuals who the government has now transported to El Salvador, to this prison, or to Guantanamo, are people who were filing asylum applications, trying to stay in the U.S. Either they had come to the U.S. and sought asylum at the border, turned themselves in to Customs and Border Protection officers, or as you said, they might have come in on a visa and then overstayed the visa and applied for asylum, saying, I can't be returned to my country. I can't return to my country because I'll be tortured or persecuted. In fact, Mr. Abrego Garcia, the individual who has the pending case, is someone who was granted humanitarian protection by a United States immigration court. And yet the Trump administration picked him up years later, as he was driving his kids to school and put him in detention and then transferred him to this prison in El Salvador. So yes, you have that right. The irony is that the Trump administration is smearing all of these individuals as gang members, either of Tren de Aragua in
MS-13.
MS-13. And the irony is that so many of these individuals are actually have a basis for asylum because they resisted gang activity and criminal syndicates in their home country. They're being targeted in their home country, and the government in their home country won't help them because they fought back against gang extortion or other gang activity.
Let's go back to Guantanamo for a second because I am stuck on the administration invested, according to the New York Times, $40 million in just the first couple of months of the administration, moving these people that you described to Guantanamo, temporarily holding them there, and then it seems like most of them have now been dispersed in one way or another. What accounts for their decision to leave Guantanamo behind? Because I have a theory, and my theory is rooted in the limits of that national security invocation, which is to say, oftentimes when the government litigates how it treats immigrants or other people in this country, when they say national security, the Supreme Court says, yes, thank you. And then there are other occasions where the government says, that doesn't work. People are still entitled to due process of law. They're still entitled to file habeas claims. Do you think what happened here with Guantanamo is that somebody or some bodies in the administration appreciated the fact that the Supreme Court had already provided that, for example, U.S. citizens who were whisked away to Guantanamo still had habeas rights, even though they weren't in the continental United States. They were still in U.S. custody, and therefore they had all of the due process rights available to somebody held in the country. And therefore the administration said, we can't use Guantanamo anymore. Is that what happened?
I think you're right, but there are two things I think that happened. One is we immediately filed litigation, number one, seeking access to counsel for anyone that they disappeared incommunicado into Guantanamo. And that after we filed those cases and got immediate relief from the courts, they then started moving people out, either deporting them onward back to Venezuela or other countries, or in one case at least, bringing the person back to the United States to be put into immigration custody where they came from.
Is this like a 1-2 punch then of precedent and enforcement?
I think it's two things. I think it's that you see a larger pattern of this administration basically playing a shell game with people's lives, with human beings. And this has happened when they move them to Guantanamo and we file a lawsuit. So then they move them out of Guantanamo. I think you're right that Guantanamo wasn't good enough for them because it wasn't enough of a legal black hole because the United States still runs that military
I want to just pause
base.
on that for a second, if we can.
Sure.
The notion that Guantanamo isn't enough of a legal black hole is a sentence that should send chills down the spine of anybody who believes themselves to be a civil libertarian, irrespective of political party.
That's
I just
right.
want to stop there and say that.
As Judge Wilkinson of the Fourth Circuit said in his order in the Abrego Garcia case, Judge Wilkinson, a notable conservative federal circuit judge, said everyone who believes in freedom should be worried about the position that the U.S. government is taking now with respect to people who are being transported and disappeared into this gulag in El Salvador. So I think you're right, Lisa, that basically the Trump administration first thought about using Guantanamo as a legal black hole, as a place to spirit people away where they'd be beyond the reach of the law, beyond the reach of lawyers, beyond the reach of family, beyond the reach of the courts. And they realized, oh, the U.S. still runs Guantanamo, and so the law can still reach them. Let's send them to a prison run by a foreign country with a friendly administration. And that's why we see President Trump with President Bukele winking and nodding and yucking it up with each other and saying, oh, we can't bring these people back. And I think, by the way, that you're seeing that now within the United States, again, this shell game that the government is playing with human lives. So when
moving people, for example, from one ICE facility where, for example, the ACLU might have a favorable ruling to a place where it doesn't have any ruling. Is that what you mean by that?
Exactly right.
Okay. I want to switch and talk about a different variant of an immigration problem, and one that is probably as far away from people who are sent to Guantanamo or CICOT as possible, right? People who get sent to CICOT, by and large, lack education. For example, I'll raise Mr. Abrego Garcia's case. He was working toward, my understanding is he was a union apprentice working as a sheet metal worker. The people I want to talk about now are the people that could be our classmates, our children's classmates at some of the most prestigious universities in the world. People like Mahmoud Khalil or Rumeysa Ozturk, who is the Tufts graduate student who was arrested on the street, or Mohsen Madawi, who was arrested literally at his naturalization interview. For people who are not familiar with that term, that is one of the last steps an immigrant takes toward becoming a U.S. citizen, is to show up for an interview and for a citizenship test. These are all people who are graduate students at U.S. universities. In some cases, they had student visas. In other cases, they are lawful permanent residents, as was Mr. Madawi. What I'm trying to understand is the provisions under which the United States government appears to be attempting to deport these people is one that is A, not well used in the past, B, without a lot of case precedent, and C, by the statute's plain language itself, allows the Secretary of State to make a personal determination that an individual's past, present, or even expected beliefs or speech pose a compelling foreign policy problem with respect to the United States' interests. And so I guess my question to you is, am I right that these haven't been tested before in our courts? And with respect to that particular speech provision, right, it basically says you can't punish somebody for their speech unless the Secretary of State makes a personal determination that there is a compelling foreign policy interest in having them removed from the country. Do you expect that that's going to hold up as constitutional or not?
I think that the actions that the government has taken to deport people based purely on their First Amendment protected speech will fail in the courts. We, of course, represent several of the individuals that you mentioned who are fighting back through habeas corpus petitions in the federal courts. Let's be clear about what Marco Rubio has said. In the case of Mahmoud Khalil, this is someone who engaged in peaceful protest at Columbia University, where he's a recent graduate. He is a lawful permanent resident, a green card holder. He is arrested as he's coming home to his student housing at Columbia with his U.S. citizen wife, who, by the way, was 7 months pregnant at the time.
And has recently given birth alone to their firstborn child.
That's right. While our client, Mahmoud Khalil, is detained in a Louisiana ICE facility. Rumeysa Ozturk, also someone who is here in the United States lawfully, a graduate student at Tufts, is arrested on the sidewalk as she is going to an iftar meal during Ramadan. What did Rumeysa Ozturk do? She wrote an op-ed. She didn't engage in peaceful protest even. She wrote an op-ed.
Let me stop you there for a second. I want to kind of pose a more challenging question to you. I'm Jewish in my personal community, meaning my friends, my family. I hear a lot of a line of argument that goes something like this. Being in the United States is a privilege. Studying at a university like Columbia is a privilege. Having a student visa is a great privilege and responsibility. And if with that privilege and responsibility you engage in anti-Semitic, anti-Zionist speech that endangers the health and safety of other students, you should not have that privilege. How would you respond to that? And I'm not asking you, Cecilia Wong, to respond. I'm asking, what would the ACLU response be to people who say, this was a country that was unsafe for Jewish students because of the activities that people like Mahmoud Khalil and Rumeysa Ozturk engaged in?
So I'll say a few things in response. The first one is that there are laws that both protect people's First Amendment rights to speech, particularly in the context of academic freedom on campus. But there are also laws, Title VI in the civil rights statutes, that protect people from harassment on campus. So if my speech tips over into harassing someone else, that is not okay. That's not okay under the law. And universities can take action. The government can take action to restrict to that speech. In the cases that we're talking about, Mahmoud Khalil, Rumeysa Ozturk, no one in the government has come forward to say that anything they did or said verges into harassment. Mahmoud Khalil engaged in peaceful protest and was a leader of peaceful protest and famously was a negotiator with the university during those protests. Rumeysa Ozturk wrote an op-ed. And nothing in that op-ed, no one alleges that anything she wrote in that op-ed is anti-Semitic or constituted harassment of others. The second thing is a more fundamental point, Lisa, and that is that people have First Amendment rights. And the idea that the President of the United States or the Secretary of State can use this law that no one ever heard of before this in a way that is unrestricted by the Constitution to punish people for what they say because the president disagrees is really chilling to the bone.
Can I ask you a question about that? When you say that nobody had ever heard of, has the ACLU ever before litigated the lawfulness of that particular provision that Secretary Rubio has invoked here? The so-called foreign policy provision?
Not that I know of. And I'm confident that through our litigation on behalf of these individuals, Mahmoud Khalil, Rumeysa Ozturk, Dr. Badr Suri Khan, or Badr Khan Suri, that the First Amendment has to put limits on what the Secretary of State can do in using this so-called foreign policy bar in the immigration laws.
I'll make you a prognosticator for a second. One way or another, I'm not asking you to predict which of these cases will. Do you think that the constitutionality of the foreign policy provision will reach the Supreme Court?
I don't know. I think there are so many outrageous actions and policies that the Trump administration is effectuating right now. There's such a vast volume of litigation. They can't all reach the Supreme Court. And I just don't know.
Let's talk about the Supreme Court if
Sure.
we can for a second, because you do have a case that is barreling toward the Supreme Court on May 15th. It will be the first oral argument on a Trump administration policy, and it's the Birthright Citizenship Executive Order that purports to take away birthright citizenship from children born to non-citizens on U.S. soil after a particular date in February. Obviously, we're long past that. And the particular way in which this application is coming before the court is really interesting, too, because this is not after what people like you and I would call a full-blown appeal on the merits. This is the government asking the court to rule on a very particular question, which is, each of 3 courts have entered preliminary injunctions against the efficacy of this executive order. And they're asking the court, essentially, grant what's called a partial stay. Tell each of these courts that to the extent that their orders have any validity, they only have validity in the actual jurisdiction in which they are judges. So, for example, the District of Massachusetts, which is the entire state of Massachusetts, or the Northern District of California, which is 1/4 of the state of California, at least as it's broken up into judicial districts. Why do you think the court took oral argument here? Because I've heard both sides. I've heard friends say, ooh, this is a bad sign. Every time since the 1970s that the court has entertained oral argument on a shadow docket application, meaning a case that doesn't have full briefing, every time they've done that, the petitioner has won, and here the government is the petitioner. I've also had people tell me, don't read too much into it. This is an important issue, and to the extent that the court is going to go against a presidential executive order, they want to do so after a full public vetting of the issues here. How do you see it?
So I think I'm in the optimist camp here. I don't often make predictions about what the Supreme Court is going to do. But on January 20th,
that's like all I do. You know that, right?
We have different jobs. I don't like to predict what courts are going to do in my cases because if I have to predict, I'll be optimistic. That's why I do what I do. When the president issued the Birthright Citizenship Executive Order on Inauguration Day, we were ready to go. We filed the first lawsuit along with our partners against the Birthright Citizenship Order. And I should add, though, that our case is not in front of the Supreme Court for argument on May 15th. That's 3 consolidated cases, one led by the state of Washington, one led by the state of New Jersey, and another one brought by Casa de Maryland and the Georgetown Clinic as their attorneys. I'm in the camp of the optimists here because, number one, the court refused to stay the lower court orders that enjoined the Birthright Citizenship Executive Order.
Meaning they could have done it immediately, and instead they said, we're not going to do that, but you can come back before us on May 15th and we'll hold an oral argument, and our resolution of this is pending oral argument.
That's right. That's right. So the Supreme Court didn't do what the Trump administration asked it to do, which was to block the lower court orders that protected the people who are affected by the Birthright Citizenship Order. I think what's interesting about it, and the reason I'm optimistic that the fact that they set oral argument is not a bad sign, is that this is probably one of the most extreme things the Trump administration has done. And, after Inauguration Day, I said, he's really going after Reconstruction. He's trying to turn the clock back in our country to the days before the Union prevailed. in the
Can you
Civil
play
War.
that out for people who are not like you, constitutional lawyers or legal historians? What does it mean to undo Reconstruction? Because the gravity of that just hit me, but I don't know that that will be evident to anybody. Not everyone watching on YouTube will understand exactly how dramatic what you just said is.
Sure. So after the Civil War was over and slavery was abolished in our country and the Union prevailed, we had to reconstruct the country and reconstruct our Constitution. We took a Constitution that had slavery built into it and abolished it. And one of the things that Congress did in framing up the Reconstruction Amendments, the 14th Amendment, with not only its protection of equal protection of the laws, but also its promise of birthright citizenship, was to overrule one of the most evil Supreme Court opinions in the court's history, the case of Dred Scott, right? This was a case that held that someone who was formerly enslaved could not be a U.S. citizen merely because of the fact that he was Black. And so in the 14th Amendment, which everyone thinks of as providing for equal protection of the laws, Congress also framed and eventually the country ratified the promise that in the United States of America, unlike so many of the countries that our ancestors come from, if you're born in this country, you're a citizen of this country. Your parents, where your parents were born doesn't matter. The fact that you or your ancestors were formerly enslaved African Americans doesn't matter. If you're born here, you're a citizen. That's fundamental to what it means to be an American, and it's fundamental to what the United States of America is as a nation. So,
But is your contention that in addition to unraveling birthright citizenship, this is an administration that is deliberately bent on also unraveling the dual promises of due process and equal protection?
absolutely. I think we see that in almost every one of these executive orders, in all of the positions that this administration is taking in defending against lawsuits where people are trying to assert their rights. They are running roughshod over the due process clause. They are running roughshod over the idea of equality. They are running roughshod over the idea of freedom of speech, freedom of the press. This really is an administration that is trying to attack the foundations of what the country is ever since Reconstruction, since the end of the Civil War.
So let me ask you a provocative question. My first episode, I had Deborah Pearlstein of Princeton University here, and we jokingly put a bunch of things that the administration had already done or was teasing doing into buckets. And the buckets were OMG, blatantly unconstitutional. I'm sorry, I'm from the San Fernando Valley. It's like my birthright to talk like that. OMG, blatantly unconstitutional, lawful but awful, and it depends. I want to focus with you, Cecilia, on the middle bucket of lawful but awful. Are there policies that you look at from a legal perspective right now that you think about with your team? Could we challenge that and ultimately conclude, that really doesn't sit right with me, but when tested in a court, the conclusion will likely be lawful but awful?
I can't think of anything in that bucket for the simple reason that so many of the actions that this administration is taking are completely unconstitutional and, right on the face of what he's saying, just go against either a federal statute enacted by Congress or the plain language of the United States Constitution.
Well, then there's got to be a resource allocation issue, right? Like the ACLU, you oversee 200 plus lawyers, you coordinate with hundreds more in the states. But at the end of the day, the ACLU can only do so much. When you are sitting atop the National Legal Department and thinking, where are our resources best expended? What makes a case right now an ACLU case versus a case that you say to yourself, you know what, somebody else can do that and do that very capably? What are the cases where you think we need to be at the head of this, at the tip of this spear?
So we've brought over 40 cases challenging the Trump administration. The number grows every day because our ACLU state affiliates around the country are bringing habeas petitions on behalf of people who have been subjected to the Alien Enemies Act. These are follow-on cases to JGG versus Trump. And now increasingly, ACLU affiliates are running into court to protect current students at U.S. universities who are having their student visas revoked. Those are really driving up the number of cases that we're bringing every day. It's a struggle to keep up. The things that make our cases ones that we prioritize are that, number one, Trump is going after people that he considers to be disfavored. So initially, we've brought probably the majority of the 40 plus cases we've challenged are immigration related cases.
Was that true of your caseload before January 20th? If you were to look at the cases brought by the National Legal Department, what percentage of them were immigration cases in a before world versus an after world?
I think the number of cases that we are bringing is certainly increased since Trump took office for his second term. The volume of his policies and the volume of our litigation and response have gone up at a steep rate as compared to his first administration. You know, don't get me wrong, we brought plenty of lawsuits against the Biden administration as we did against the Obama administration. We are in the business of holding the government accountable when it violates people's rights, and we're not looking at whether the president is a Republican or a Democrat. What we are looking at is, what are the violations of the Constitution? How is the president violating federal statutes? And so our focus really has been, number one, immigration, because he's gone after immigrants, including green card holders and people who are lawfully in the United States. Second, transgender youth. So we've brought a number of cases challenging Trump's policies against transgender people, transgender Americans. Third is policies that go after something he calls DEI, diversity, equity, and inclusion, and what I would call an all-out attack on two fundamental promises of the U.S. Constitution. One is civil rights laws and the promise of equal protection of the laws, regardless of your race, your ethnicity, your gender. And number two, many of those orders where we're challenging his attack on something he frames as DEI are really about censorship. So, for example, we've brought suit to challenge the Defense Department runs K through 12 schools on military bases. And they have censored the books and the curriculum offered in those schools. You can't mention LGBT. You can't mention a history of racism in this country. And so they've banned certain books. We're representing students and their parents in those military K through 12 schools to challenge those book bans. That's censorship in violation of the First Amendment, pure and simple. We have challenged a policy of the NIH, the National, there's a government-run website called PSNet, which publishes scientific studies. So these are medical journal articles, things of that nature. That is now being censored so that trigger words like vaccine hesitancy, again, LGBT, transgender, those words now lead to the censorship of scientific research on a government-sponsored website. We've sued to challenge that. I can go on, but we're really focused on areas where the president, number one, is trying to suppress, repress, and violate the rights of individuals based on their race, their gender, or their immigration status. And fundamentally, what we've done across the lawsuits we've brought, the amicus briefs we filed, and all the cases we're developing that are in the pipeline, is to protect individual Americans' freedom from a president who is dead set on taking those freedoms away.
I'm going to have to stop you there because you have to get back to fighting good fights and I have to get back to covering them. Cecilia Wong, thank you for joining us on this episode of Can They Do That?
Thank you so much, Lisa. It's been a pleasure.